On August 20th, 2025, the United States government took a significant and controversial step. It imposed economic sanctions on 4 senior officials of the International Criminal Court. The action was announced by the U.S. Department of the Treasury's Office of Foreign Assets Control, OFAC. The State Department publicly supported the move. The U.S. said the court attempted to assert jurisdiction over nationals of the United States, over its allies, specifically Israel. The move signals a serious escalation in the long-simmering tensions between Washington and the court in The Hague. The 4 individuals named hold prominent positions within the ICC. Nicolas Yan Guillou, a judge from France; Nazat Shamim Khan, judge from Fiji; Kimberly Prost, deputy prosecutor from Canada; Mimi Mandiaye Nyang, deputy prosecutor from Senegal. These officials were directly involved in proceedings the U.S. found objectionable. By targeting specific individuals, the United States aimed to send a forceful message. The sanctions are not just symbolic. They carry real financial and personal consequences. The primary reason cited by the United States for these sanctions is the defense of national sovereignty. U.S. officials argue that an international body to which the nation has not consented cannot hold legal authority over its citizens. The State Department articulated this position clearly. A spokesperson said the ICC's actions are an unacceptable threat to U.S. and allied interests. Accountability for American personnel, they say, should be handled exclusively by the American justice system. The U.S. says its military and civilian courts are robust and sufficient. The U.S. says it can investigate and prosecute alleged crimes. Therefore, external oversight is unnecessary and illegitimate. The administration views the sanctions as a necessary deterrent. The goal is to discourage the ICC from pursuing future investigations and prosecutions aimed at Americans or at citizens of allied non-member states. By imposing costs on the officials involved, Washington hopes to create a chilling effect. The strategy is meant to make the court's prosecutors pause. The International Criminal Court and its supporters have responded to the U.S. sanctions with alarm and condemnation. They argue these measures are a direct attack on judicial independence and the international rule of law. The court's leadership calls the sanctions an attempt to intimidate and to obstruct the course of justice. An official statement from the presidency of the Assembly of States parties called the measures deeply troubling and an affront to the court's mandate. The ICC says its officials must work impartially without fear of retribution from powerful nations. Human rights organizations and legal experts worldwide have echoed these concerns. Amnesty International and the Human Rights Watch both call the sanctions a dangerous assault on the global justice system. They warn that targeting judges and prosecutors for doing their jobs sets a terrible precedent. It could embolden authoritarian regimes to target any judicial official, domestic or international. At stake, justice should be blind. Judicial actors should not be punished for legal decisions. Many of America's closest European allies have voiced disapproval. The sanctions imposed by the United States have immediate and tangible consequences for the targeted officials and the court itself. The most direct effects are personal. The 4 officials now face having their assets frozen if they are held in U.S. financial institutions or involve U.S. currency. They are also subject to travel bans, preventing them from entering the United States. Beyond these direct measures, the sanctions create a broad, chilling effect. Banks and financial institutions around the world, wary of running afoul of U.S. regulations, may refuse to do business with the sanctioned individuals, complicating their personal lives, complicating their professional lives in profound ways. These practical harms extend to the institution of the ICC. The court's operational capacity could be significantly hampered. Investigations often require international travel, financial transactions, cooperation with a wide range of actors. If prosecutors, investigators, or even potential witnesses feel intimidated or fear being targeted by sanctions, they may be less willing to cooperate. This can slow down or even halt critical investigative work. The current standoff between the United States and the International Criminal Court presents two divergent paths for the future of international justice. The first path is one of continued confrontation. On this track, a powerful state like the United States continues to use unilateral measures, such as sanctions, to protect its perceived sovereign interests and shield its citizens and allies from the court's jurisdiction. Other powerful nations might follow this example, creating a fragmented system where international law is applied selectively. This approach risks normalizing the act of sanctioning judges, fundamentally weakening the independence and effectiveness of international judicial bodies. This path of confrontation could lead to a world where accountability for mass crimes becomes increasingly politicized. International courts might become battlegrounds for geopolitical rivalries rather than impartial forums for justice. The ICC, deprived of cooperation and facing active obstruction from major powers, could find its work severely limited. While this approach might succeed in protecting the short-term interests of specific nations, it comes at the high cost of eroding the global framework for justice that has been painstakingly built over decades. The long-term risk is a return to an era where impunity for the most powerful is the norm. The second path is one of dialogue and multilateral cooperation.